Good afternoon. A warm welcome to another coffee date with Conflict Dynamics. We've designed these sessions to focus on very practical matters which impact HR and ER practitioners particularly, as well as any line manager, typically on a day-to-day basis. And hopefully you have a good cup of coffee or tea or really any other drink of your choice, I guess, in hand. And I invite you to take a time out now over the next hour as we received some valuable insights from today's speaker. And we strive to answer as many of your questions as we can in the time that we have available. My name is Vanessa Buerta. I am the training manager for Conflict Dynamics, and I will be hosting the session today. Our discussion today is going to focus on what you, as possibly, potentially an HR or ER practitioner or a line manager, need to know about harassment in the workplace. Despite the fact that South Africa introduced a new code of good practice on the prevention and elimination of harassment in the workplace, as many now as 3 years ago, still, we are finding that many practitioners and managers are still quite unsure of what's expected of them. And this is a risky knowledge gap. So we've therefore invited today's speaker, Jayashree Mudley, to cut through the legal jargon and to provide us with some practical essentials on this important topic. Just to introduce Jayashree very briefly, she is an attorney who has specialized in employment law for more than 20 years. She often represents both employers and employees at internal disciplinary hearings, and as well as the CCMA, bargaining councils, and in the labor court. And this is across all employment-related matters. But she has a particular interest and much experience in the challenging area of workplace harassment, including having conducted many investigations on this topic. Jayashree is also a long-standing and very valued member of the Conflict Dynamics training panel, as well as our dispute resolution panels. Now, just before I hand over to Jayashree to take us through this topic today, just a few quick points about the session generally. A very important part of these sessions, we believe, is the opportunity for question and answer, Q&A. And so please, if at any point you want to raise a question or a comment, about what is being said at that particular point in time, please do use the Q&A button, which you should find more or less in the middle at the bottom of your screen. And I will be keeping an eye on that Q&A button and what comes up there. And I will pose as many of your questions to Jayashree as we can do in the time that we have available. So Jayashree has indicated that she really has no issue with being interrupted, so to speak, with questions at the appropriate time. So please do feel free to post those questions as soon as they come up for you, or any comment that you wish to make. Just a general disclaimer, and Jayashree, you'll probably say the same thing. Please, of course, bear in mind that anything that we discuss or respond to in today's session really can't be construed as formal legal advice, as there'd have to be, a very deep dive into the facts of a matter in order for that to be the case. And also just to mention that, as always, a copy of Jayashree's slides as well as a copy of the recording of the whole webinar will be made available to everyone who's in attendance. And we'll do that within the next couple of days. So without any further ado, welcome to Jayashree. Thank you so much for taking the time to be with us today. And for now, over to you.
Thank you, Vanessa. And good afternoon, everyone. Thank you for joining us this afternoon in what I hope will be a very interactive and interesting webinar. As Vanessa has said, please feel free to raise your questions, even if it does interrupt my presentation. Sometimes if you wait to pose your questions at the end or the question gets dealt with at the end, you lose your train of thought and you might forget. So this is not a presentation or a lecture that I'm going to give. I hope that it will be interactive and it will be interesting. So today's webinar, although I am an attorney, it is not about legal issues. It's not about case law, although there is reference to one case that I will be making. But you're not going to get a case law update. If you look at the topic, it's self-explanatory. We're looking at what every HR and ER practitioner or manager needs to know about harassment. So we are talking about harassment in the workplace and from the time it first arises. Sometimes by the time it gets to the ER managers or it gets to the lawyers who act for a company, you already have a full-blown dispute. And then people like us who deal with these harassment cases at arbitration or labor court stage, then backtrack and see, so what happened when the issue first arose? And it's important then for HR and ER practitioners to understand, what do we need to know on the ground? How do we deal with these issues on a day-to-day basis? And what are the consequences of us not dealing with these issues? So this is what I hope to unpack today with you. I don't know whether most of you have even seen or read the Code of Good Practice. It is a very new Code of Good Practice that got introduced into law or was gazetted in March 2022. So it's 3 years since then. And a lot of employers have not yet unpacked the code. And to some managers, also, it might seem to be very overwhelming. It is a long code, although it's written in a fairly explanatory fashion. Sometimes it is difficult to unpack. What do we do as line managers, as HR practitioners? How do we deal with this code? What are we supposed to do? So without further ado, I'm going to move on to just talking a little bit on what the Enabling Act is insofar as the code is concerned, and also talk you through the relevant and important portions of the code. So the first part of this webinar, this presentation, would be explaining and unpacking some theoretical aspects of the code, and then moving on to some practical steps. How do we deal with this in terms of procedure? What does the code tell us? And how do we implement it at an HR level, at a line manager level, or even at an ER level before a dispute goes external? So the first thing you need to know about is the Employment Equity Act. It is the Act of 1998. I will refer to it in the slides as the EEA. And that came into operation in December 1999. So your purpose of your Employment Equity Act, remember, it's based on the equality provisions of the Constitution. But your purpose of the Employment Equity Act is to achieve equity in the workplace by eliminating unfair discrimination, firstly, and secondly, by promoting equal opportunities and fair treatment for all employees. Now, the Code of Good Practice on the Prevention and Elimination of Harassment in the Workplace was introduced as a Code of Good Practice to this Employment Equity Act, and it replaced the old Code of Good Practice on sexual harassment that was in existence prior to March 2022. Now, when you look at the Code of Good Practice, it's focusing on the first purpose of the Employment Equity Act, which is to achieve equity by eliminating unfair discrimination. If you have a look at what the code, what is contained in the code, it says the code is intended to address the prevention, elimination, and management of all forms of harassment that pervade the workplace. It is guided by International Labour Organization conventions. So South Africa is part of the ILO, and our policies, practices, legislations are fashioned along the guidelines of the ILO. But if you look at this, it says the code is intended to address not just the elimination of harassment in the workplace, it also talks about preventing. And that's what we need to focus on as HR and AR practitioners, or even line managers. How do we prevent, or how do we manage all forms of harassment that pervade the workplace? And that is what we're going to unpack as we go along in this webinar today. So if you look at the next slide, the Section 6 of the Employment Equity Act is what we call your discrimination clause. Now, this clause or this section prohibits unfair discrimination directly or indirectly. Okay, this is not how looks in the Act. This is telling you what the section is about. But if you read the section, it says it prohibits unfair discrimination directly or indirectly on specified listed grounds. So some of the specified listed grounds that you have in Section 6 is you're not allowed to discriminate directly or indirectly on grounds related to gender, race, sex, political opinion, medical reasons, medical conditions, HIV status. So there's quite a few specified listed grounds in Section 6. It also talks about any other arbitrary ground. So arbitrary grounds are best described as those that are similar to the listed grounds, which also causes a person's dignity to be impaired, but there's no rational basis for that conduct on an arbitrary ground. It's a conduct that happens almost like on a whim, or there's no foundation, okay? So your unfair discrimination can happen directly or indirectly on a listed ground or any arbitrary ground. But what's important for our purposes today is also to look at Section 6.3, which provides that harassment of an employee is a form of unfair discrimination, and it's prohibited on the grounds that are listed in Section 6.1. So this section underpins the Employment Equity Act and more so the Code of Good Practice on the prevention and elimination of harassment in the workplace. And on the next slide, you will see that it's an extract from the code where it says that South Africa regards all forms of harassment as a form of unfair discrimination, and which constitutes a barrier to equity and equality in the workplace. Therefore, all forms of harassment, and this is where the code describes it, it says all forms of harassment such as sexual harassment, gender-based violence and harassment, bullying, racial, ethnic, or social origin harassment must be eliminated. Now, that's my emphasis on the word must, but you can see that the code is very prescriptive and talks to what has to be done. The code also stipulates that all forms of harassment against women, men, LGBTQIA+, and vulnerable persons in the workplace is an abuse of power, okay? So you can see the code unpacks a lot more than what the Act or what the Code on Sexual Harassment talks to, and it talks to including vulnerable persons, members of the LGBTQIA+ community, and prohibits all forms of harassment against employees in the workplace. The code also identifies what steps must the employer take to eliminate harassment, okay? Things like, which we will talk about later on, including the development of and implementation of policies, procedures, and practices. What should you have in your policies? What procedures should you have in the workplace that is user-friendly to your employees? What practices should you have in your workplace that would give effect to the code? Okay. And all of this, the code is looking at is that you can then create a workplace which is free from harassment and where employers and employees respect one another's integrity, dignity, privacy, and their right to equality in the workplace. But before I leave the slide, what I must mention is everyone knows we have a constitution, we have a Bill of Rights. But in the constitution, we also have your limitation clause, which is your section 36 clause, which says that in certain situations and circumstances, your rights can be limited. So again, in the workplace, we got to look at, for example, your right to privacy. You don't have an absolute right to privacy in the workplace, okay? But to what extent then does any conduct impinge on this? And do you have a right to privacy, or does the employer's operational requirements or the interests of other employees take precedence? So these are things that we will look at a little bit as we go along as well. And to continue, dealing with the
Sorry,
code, if you look
Jayshree,
at
can
the
I just interrupt you for a second with a quick
show,
question, which is relevant to this particular part of your discussion? We have
yeah,
someone who's asked if you could possibly just give a few examples of arbitrary grounds for discrimination.
yeah. Okay. You really, when you have an arbitrary ground, you can't really articulate it because it's something, if it was a listed ground, obviously it'll fall under your section 6 categories. So your arbitrary ground is something that is, it's like the person, whoever is perpetuating the conduct, is having a what you say, differentiating in treatment of employees on something that is without foundation. It's like, I'm going to pay two employees differently, but there's no rational reason for them doing that. And both those employees who are being paid differently, for example, are not from different genders and they're not from different races. But it's difficult to understand what is the rationale. Both started at the same time, both have similar qualifications, both are doing the same jobs. What is and what is causing this? Why is that person being treated differently? So that becomes almost like what we say, an arbitrary ground. There's no foundation for it. It's something that is based on maybe the whim of the manager, a fancy. So that is why you will say it's on an arbitrary ground. So you can't really give an exact example of an arbitrary ground. It'll come out of the facts of the case or the differentiation in the treatment. Remember, with discrimination, it talks about differentiation in treatment, but that's one aspect. You've also got to look at, does it amount to discrimination? Okay, so the arbitrary grounds are very difficult to prove. Normally, if it's a listed ground, the employer then bears the onus to show that there's no discrimination, and that even if there is discrimination, it's not unfair. With an arbitrary ground, an employee bears the onus to show that there is discrimination. So it's a bigger onus to bear. Very few cases really run successfully based on an arbitrary ground because it's so difficult to prove. I ran an arbitration myself where we had an issue where two employees were being paid differently, and we referred the dispute based on an arbitrary ground, and unfortunately we lost because we couldn't tie the reason as to something that justified that differentiation. So I know it's not a clear-cut answer, but that is why they say so broadly arbitrary grounds. So the courts have said as well, you look at something that has no foundation, it's like on a whim or a fancy, that would be something that would be an arbitrary ground. Okay.
Yeah, thanks for that. We also have a comment from Londeka who says that in addition to what you've described, there simply isn't usually any logic to
Yeah,
the ground. Yeah, yeah.
absolutely. Thank you, Landeka. That really may, yeah, it clearly illustrates that.
Yes.
Okay.
Janet has also said that it's going to be interesting to see how arbitrary grounds are argued in the light of the Fair Pay Bill.
Yeah, well, that's going to open a whole lot of more issues. You will even see as we go along. There's so many things that are happening now in the employment law space where there's so many things that are changing. that there's going to be a lot of new judgments that we have to watch out for to see how are the courts interpreting these sections. Okay, like we said, we had one judgment, I don't know it off the top of my head, which says your arbitrary ground is something that it has the impact of impairing an employee's dignity, but it must not, it's not based on anything solid, like a solid foundation. So yes. Okay, so let's carry on with dealing with the harassment. So continuing with what the code sets out, the code deals with the definition of and the different types of harassment, and also the test for establishing whether a specific type of harassment took place. Now, unfortunately, we do not have enough time in this webinar to go through every single type of harassment listed in the code and all of the tests, but I will point out to you as we go along what is important for you to know, or which sections of the code you can read on your own that unpacks the tests, for example, for sexual harassment or racial harassment. But let's look at what is harassment, because harassment is not defined in the Employment Equity Act. It says harassment is a form of unfair discrimination, but in the definition section of the Act, you don't find a definition of harassment. The code says that it is understood to be unwanted conduct. Now, there's a primary focus on these words, unwanted conduct. If you look at the case law, the arbitration awards and the labor court judgments that come out, the first inquiry is the conduct complained about unwanted? Okay, so it's very important for conduct to amount to harassment. It first has to be unwanted conduct. Then we look at the impact. The impact of that conduct has to be that it impairs another person's dignity. Okay? And the third aspect of harassment is that conduct then must create or result in a hostile or an intimidating work environment. And your hostile work environment is also defined for you in the Code of Good Practice. And it talks about where employees are in an environment where they are subjective to abusive conduct, okay? And where that conduct has a negative impact on them, and where it impacts also on their ability to do their work. And then finally, the conduct is related to the grounds that are listed on your in section 6.1, which is your listed grounds or any arbitrary grounds. So the code then sets out, this is what we understand harassment to mean. But the case law focuses a lot on the unwanted conduct and impairing of the dignity. It looks at the impact on the complainant. And finally, you see that the code is very broad in its applicability. It doesn't only cover employers and employees like the Labor Relations Act does, okay? The code covers job applicants, clients of the company, suppliers of the company. It even extends to volunteers who are at the company. So you can look at that and read it in detail in the code. All right, so if we move on to the next slide. So let's look at the conduct or the behavior must be unwanted. What the code looks at in terms of unwanted conduct is that, firstly, did the complainant communicate to the harasser that this conduct is unwelcome? And this communication can be verbally or it can be non-verbal. In one judgment, the court accepted that the complainant walked away from the perpetrator when he committed the harassing behavior. And the court said by her walking away, that was communication non-verbally. Okay? So the complainant must communicate to the harasser that this behavior is unwelcome or the conduct is unwelcome. And secondly, even if there is no such communication between the complainant and the perpetrator, the court say, or the test is, you've got to look at, did the perpetrator know or ought to have known that that sort of conduct is unwelcome or it's generally considered to be unacceptable? Okay, so would any employee know that you shouldn't touch another employee inappropriately in the workplace? So even if the complainant didn't react at the time, the fact that the perpetrator should have known that that conduct is unacceptable is sufficient. Okay. And very importantly, the intention of the alleged perpetrator is not the focus here. Okay. The focus is on the impact of the complainant. So even if someone says, I didn't intend to harass the person, that is irrelevant to a certain extent in establishing whether the harassment occurred. Okay. Obviously, the intention will play a role if you are in a disciplinary process and if you are looking at a harsher sanction or the surrounding circumstances. But to establish harassment, the intention of the perpetrator is not the focus. And when you look at the impact, it is seen from the perspective of the employee who alleges the harassment. Okay. So if you look at paragraph 4.45 of the code, and I read from there, it says the primary focus of the inquiry as to whether there has been harassment is on the impact of the conduct on the employee. And then the code goes further to say there may be circumstances where that person, the views of that person, of the complainant, are not consistent with the views of a reasonable person in the same position. So the test then is we look at what was the impact on the complainant, and then would a reasonable person in the position of the complainant also have felt the same way? And that is your reasonable person test that the code looks at. And then if we look at your different forms of harassment, which I said we shall look at, and we don't have time to go into this in great detail. So we're looking at the code covers racial, ethnic, or social origin harassment. Okay. And if you look at paragraph 6.5 of the Code of Good Practice, or paragraph 6, it sets out what amounts to racial, ethnic, or social origin harassment. It's defined there. It also sets out what the test to determine racial harassment is. And what is very interesting is the code in paragraph 6.5 refers to a constitutional court judgment of Rustenburg Platinum Mines versus Bester and others, and talks to that the Constitutional Court has emphasized when you are determining whether language or conduct is racial or derogatory, we must take into account South Africa's history of institutionalized racial discrimination. And the test to be applied in identifying whether the language is racist or not is whether it's reasonably capable of conveying a racist meaning to the reasonable hearer. Again, we come back to a reasonable person in the place of the complainant or the employee. Did that conduct amount to being, would it be racist? Would the remarks be racist? Okay. And then again, with sexual harassment, that's dealt with in paragraph 5 of the code. It talks about the different types of harassment. Again, there's a focus on the unwanted conduct. It also talks about when that a single incident of sexual harassment is sufficient. It doesn't have to be repetitive behavior. Okay. And it also sets out the test for sexual harassment. What is interesting from the code is that it now looks at and talks to workplace bullying, because we never had workplace bullying defined anywhere before, neither in the Code of Good Practice dealing with dismissals or in the Labor Relations Act. But workplace bullying now in the code is described as involving aggressive behavior, which someone repeatedly causes, which causes another person injury or discomfort. And So workplace bullying is now also recognized as a form of harassment that pervades the workplace. The other forms of harassment that are also dealt with, and these are just some of them, are the psychological abuse that can happen. And post-COVID, we are dealing with a lot of online interactions, working online, working remotely. So it also covers and deals with online harassment. And this includes even cyberbullying. So even the sexual harassment, if you look at it, it talks about how it can even happen online. Okay. And a further interesting aspect of the harassment that is covered is the code refers to passive aggressive or covert bullying. And it describes what sort of conduct can amount to passive aggressive or covert bullying in the workplace, which are things like negative gossip, negative joking at someone's expense, being sarcastic towards another employee, condescending eye contact, facial expressions or gestures, mimicking somebody, deliberately causing another employee embarrassment or ridicule or insecurity, marginalizing certain employees, excluding certain employees from social events, isolating certain employees professionally, and deliberately sabotaging someone's dignity. So you can see the code is very, very broad. It covers a broad range of issues that employees can experience in the workplace, which may amount to harassment. Okay. And the harassment can be a result of your physical, verbal, or psychological conduct. Okay, so that,
Jayshree,
sorry.
before you move on,
Yeah.
um, this is a challenging one, but I think it's something that is plagues many workplaces with the nuance that it comes with. Janita
Yeah.
has asked or has firstly stated that sometimes bullying is indirect, and then she asks, how can the employer prevent this when the bully says that they are being misunderstood?
In some of the training we do at conflict dynamics for certain clients, we always look at when you're dealing with workplace bullying, what are the justifications or the justifying behaviors a bully can put up? And one of the things is that they are being misunderstood, or this is their style and it's worked for them before. They are developing junior employees or subordinate employees to be stronger people. So obviously, workplace bullies will use that they are misunderstood to justify their behavior. Remember, again, sometimes some people would say, I had a training session that I was doing as well, where people complained and said, we were brought up in a certain way. And when we go into an office, we greet a manager. We say, good morning, how are you? And sometimes the managers are so rude. What do you want? Okay. In one instance, a young gentleman told me he got asked, why are you asking how I am? What are you, a doctor? So he says, he doesn't even ask, how are you? But the manager as well, who was justifying the behavior, also said, well, I'm not a morning person. So I'm going to work early in the morning and I am dealing with what I have to deal with. Now you coming into my office all chirpy and saying, good morning, how are you? And wanting to have a conversation with me. And I don't want to have a conversation with you. I'm not a morning person. I want you to get on with your job. So obviously, because there's different styles, we all come from different upbringings, there's different genders, different ages in the workplace. You're going to have these sort of issues that are going to arise. But Juanita, what we're going to talk about just now is you have an informal process that the code allows you to follow, where employees can come together in an informal process and talk about this and say, look, I think I'm being misunderstood, but maybe they will also hear how their behavior is impacting on the employee concerned, and they can both make an effort to understand where each other is coming from. So that's the good thing about this code. It allows for the informal process to be followed where these issues can be fleshed out and resolved, maybe by way of an apology or understanding each other better in the workplace. I hope that answers the question.
Yeah, as I said, I think it's a tricky question, but thanks for that. We have someone who, sorry, if I can just get there. Jogini, forgive me if I've pronounced your name incorrectly, but who makes an important point, and that is to say intent and impact. Intent and impact are important factors to unpack in these kind of situations.
Yeah, but the thing is, with the code, it focuses a lot more on the impact. So even though the behavior may be unintentional, I may not have been intentional, or I do not want to intentionally hurt you by my conduct. Okay. But so the intention, the impact is more important in this case than the intention, although the intention plays a role to a certain extent.
Yeah,
Okay.
briefly, here's another question still on the bullying topic. Maybe if we can fit
Okay.
one more in. Harry has asked, how would you objectively confirm that a person is a bully? Giving instruction and demanding certain standards is not bullying, but it often is called bullying.
Yeah. So there is a fine line in the workplace between somebody having a perception that a certain type of behavior is bullying, but they have an unreasonable work expectation. So where you have a manager saying, this is how I want the work done, and this is the deadline by when the work has to be done, or this is how I want the work done. And the person might perceive that to be bullying because maybe they have come into that workplace and they have an unreasonable expectation of what the work should be like. I always use this example, and like in a law firm, you have new candidate attorneys who are coming in expecting to have an experience like how you see on American TV with Suits, for example. This is how it's going to be. Instead, reality is different. You with the principal, you're working in a different department, your deadlines are tight, you're working late hours, you don't have a life sometimes. And you might have a manager who's very demanding. So you've got to look at and balance, is this actually bullying, or is the employee, the complainant, having an unreasonable work expectation? There's a fine line between that. And some people, especially new employees to a workforce, may misinterpret it and say, I believe I'm being bullied. But maybe that is the approach of that workplace. So it's a very difficult situation to manage. You've got to look at the case, you've got to look at the facts of the case. And you also, to determine if it is bullying, also just look at is the behavior repetitive, and is the behavior reasonable? Are other managers in the same position of the manager behaving in a similar way? Okay. So that, I hope that helps as a useful guideline.
Thanks, Jayashree. I'll move on.
Okay. All right. So that's the theory. Let's look at in practice. What do we do? How do we implement this in our workplace? Because at an HR, ER, or line manager level, you don't need you to do it. You need to do it in a way that is based on the guiding principles that are contained in the code. Okay. The first thing the code says is that employers should adopt a zero tolerance approach towards harassment and discourage unacceptable behavior. And employers need to develop and implement a harassment policy in terms of the guidelines set out in the code. So two things, zero tolerance approach. If you are implementing a new code in your workplace, you can say, after we roll out this new code or this new policy in the workplace, effective from 1 October or 1 November, the employer will be adopting a zero tolerance approach towards harassment, and there will be strict adherence to the principles set out in the policy and in the disciplinary code. So have a zero tolerance approach, and you need to develop and implement a harassment policy. Some employers are saying it's too onerous to go and get a new policy and have it approved by the various levels of management that has to do it. What we are going to do is we are going to say that we are adopting the code of good practice as our harassment policy. So there's nothing wrong with that. But even if you have a harassment policy and it's silent on certain issues, you will default to what the code provides. Okay. Following on now on procedures, okay, what the code suggests is what are the procedures that an employer should follow when a complaint of harassment is made in the workplace? And these include, but are not limited to the following. The first thing, take steps to investigate the matter, okay? There's always more than two sides to the story, okay? And remember, with harassment, certain types of harassment, for example, sexual harassment, it happens in a private place, often between two people, and there are no witnesses. So it's important to investigate the issue thoroughly. So you need to take the necessary steps to investigate what happened. That also entails consulting with all the relevant parties involved, not only the people who are involved in the action, but people who may be bystanders, people who may be managers, people who may be working in the same department, okay? And then you need to take the necessary steps to deal with the complaint. How are we going to deal with this in terms of our policies and procedures? But the most important thing that a lot of people forget about, especially at the level of dealing with this issue at the workplace, because you get so focused on trying to resolve the problem, do the investigation, convene the disciplinary inquiry, you also need to take steps to eliminate the harassment. Okay, and as we move on to the later slides, you're going to see, and we talk about how do you do this? So there is a judgment I will refer you to just now when we deal with liability, where the judges said just having a disciplinary inquiry is not enough. Taking disciplinary action against the perpetrator is not enough. There needs to be more to show that you have taken steps to eliminate or to prevent the harassment from occurring. So those are the steps that the employer should follow. And in respect of the complainant, what an employer should do is inform the complainant of the informal and formal procedures available to them. I'm going to unpack for you just now what are formal and informal procedures. You need to offer advice, assistance, and counseling to the complainant. Refer them to your employee wellness or EAP. Confirm to the complainant the matter will be dealt with confidentially. That is absolutely important. Also reassure them that nothing is going to happen to them. There's not going to be any adverse consequences for them reporting the matter. Consider providing them with additional sick leave if the circumstances require it, maybe if the person needs trauma counseling as a result of the harassment. And you also have to advise the complainant of their right to lay a criminal charge if appropriate. So all this is taken out of the Code of Good Practice. Let's look at what are your informal and your formal procedures, and when is it appropriate to use your informal procedures. So these are dealt with in terms of your procedure, in terms of in paragraph 10 of your Code of Good Practice under the heading of procedures. So when you look at paragraph 10.7, it sets out your informal procedures, and it says that a complainant in a harassment matter may choose to follow either a formal process or an informal process. So in an informal process, you have a meeting where the complainant explains to the perpetrator that this conduct is unwelcome, it's impacting on them in a certain way, and it makes them feel uncomfortable. And then the perpetrator can then be given an opportunity to respond, and you can see if there is a way to resolve the issue. Sometimes certain employers bring in mediators or they bring in a third party to try and resolve the situation. There's also a provision for where someone makes a complaint and is scared of revealing their identity. So in the informal process, you can have a third party who approaches the alleged perpetrator and says, there's been a complaint that's raised. The person does not want to follow the formal, larger formal complaint, and they want me to just have a chat to you that the sort of behavior that you are exhibiting is unwelcome and it's impacting on them in the workplace, and please desist from it. Okay. And then you have your formal procedure. In terms of your formal procedure in the code, it sets out what you should put in your formal procedure. And it says that your formal procedure should have the following. For example, remember, if an employee has a complaint, they have to lodge a grievance. So you need to set out in your formal procedure, if you want to lodge a grievance, how and with whom a grievance should be lodged, the details of the grievance procedure, what is the relevant timeframes for your grievance procedure, and if the complainant is unhappy with the internal process, what options are available for them to have the matter dealt with externally, CCMA, Labor Court, Equality Court. Remember, after the grievance is lodged, the employer has the election whether to then take disciplinary action against the perpetrator, all right, in terms of your formal process. It must also be a disciplinary offense for any retaliatory action to be taken against the complainant because they complained about the harassment. And you also need to set out what disciplinary sanctions may be meted out if the person is found guilty in a disciplinary process. So the third question there is that when should the employer determine that a formal process should be embarked upon? Now, the code says that you need to assess the risk. Is there a risk to other people in the workplace if you do not take a formal, embark on a formal process? Okay. And in assessing the risk, the court says you need to look at what is the severity of the harassment, okay? And whether the perpetrator has a history of harassment in the workplace. So the employer then, the code allows the employer to utilize the formal procedure after the risk assessment has been done, even if the complainant doesn't wish to follow the formal process. So the answer to the last question there is that the employer can use the formal process if there is a risk prevalent in the workplace, even if the complainant doesn't wish to follow the formal process. Okay, so you can get more information on the formal and informal procedures that are set out in the code. What I would like to deal with is why is it important now at this point in time in this year for HR and ER managers to be proactive as opposed to being reactive? If you can look at the next
Just
slide.
before we move on to that, Jayashree,
Okay.
a couple of comments and questions here.
Okay.
Firstly, Nicola has mentioned that the most challenging matters are the ones where complainants or even witnesses of alleged harassment make anonymous reports and then refuse to come forward and to participate in any investigation or process to deal with the complaint. And she says it's very difficult to investigate meaningfully when you cannot test the veracity of witness or complainant's allegations in person. Yeah, I don't know if you would like to comment in response to that at all. Excuse me.
Look, I had one situation where a complainant in a sexual harassment matter was scared to testify. And also because she was a student, the alleged perpetrator was was somebody senior, a full-time employee at the institution where she was a student. And she cooperated. She had lodged a complaint with the counselor, but not with the, not formally. But the employer decided to take the matter up. And what they did is the complainant did agree to cooperate with the investigator. And she deposed to an affidavit with the investigator, setting out everything that had happened and why she was scared to testify. In the internal hearing, what we did is we made an application in terms of the Law of Evidence Amendment Act, in terms of the hearsay rules, to introduce that affidavit into evidence and justified why she was scared, what the circumstances were. The other side was given an opportunity to respond and oppose our application, which they did. And the chairperson then allowed the affidavit to be introduced into evidence in the disciplinary process, taking into account all of those factors. So sometimes you need to assess and ask yourself, why is the person scared to complain, to formally complain. And remember, in sexual harassment cases, where the person is in a vulnerable position, where they are a subordinate employee, or in my case, a student of an institution, they are going to be scared to face their harasser. So that is one way to do it. You can also tell them you can testify in camera. You can sit in a laptop in another room and you can testify in. We'll Zoom you in or Teams you in. And that is also another way to deal with it. But that is why when we are another objective of this webinar is that HR and ER practitioners need to encourage people to speak up in the workplace. They need to reassure them. They need to have even, reporting lines or reporting options available to employees. But yes, Nicola, it is a very, very difficult situation. It's something that is encountered in various workplaces across the country.
Linked to that, very briefly, just to mention that Mpiri says, or asks rather, what happens in the event where the perpetrator is the CEO themselves, who should be handling the case?
Absolutely. So in that case, gosh, if it's a CEO, they should be still an HR director or an executive director or somebody else. But you can ask for the matter to be determined by an impartial external person. So, attorneys like us go out and conduct investigations in workplaces and make recommendations if there's disciplinary action to be taken. Remember, the CEO is the CEO, but there's still shareholders, there's still other members or directors in that company. They are also liable. So if there is a complaint about the CEO, it doesn't necessarily have to be made to the CEO. It can be made to the other executives, or you can call for an external investigation and even ask for the hearing to be chaired by an external person. You can contract the CCMA to provide a commissioner or any of the other bodies like Conflict Dynamics and other organizations that provide chairpersons to chair that hearing. But yes, it's a very difficult. A lot of employees do not raise complaints for fear of victimization. So it's something that is prevalent.
Thanks, Jayshree. Michelle and Success, I see your questions. I'm just keeping an eye on the time. So
No, it's
I'm
fine. We
going
can take
to,
it.
sorry.
We can take it.
Oh, okay. All right, good. So Michelle asks, what is the difference in the procedure that should be followed if the harassment is taking place within the context or space of the workplace, but the perpetrator is not an employee is not the employer or employee, but rather a regular client of that business?
Okay, but the employee is the one who's raising the complaint. Am I correct?
I would assert it's not stated specifically, but I would think that's implied, yes.
Yeah. Well, it also depends on whether that person who is perpetrating the conduct as a client, is he employed by someone else or she is employed by someone else? Then maybe the complaint can be laid with that person's employer to saying, your employee is coming and harassing my employees at my workplace. But first, the complainant would have to lodge an internal grievance asking you to ask them to desist from that conduct. Because remember, the code also talks about protecting your employees from clients, suppliers as well. So this code now is broader than the Labor Relations Act provided in terms of what you can do. So it's worth a shot.
And then briefly, Success has said that they have a patient who followed an informal procedure and now wants to follow the formal procedure and says, can you advise on that request?
I don't see anything wrong with that. Obviously keep a paper trail, keep your records. That's the one thing I would tell you. So get the person to confirm they had requested that the informal procedure be embarked upon, but now they have changed their mind. They would like you to take formal action. But it depends at what stage you are in the informal process, because in the informal process, sometimes you may, there's confidential issues that have come about. So nothing that was said in the informal process then should be relied upon in the formal process, just to have a fair process, I would say.
Thanks, Jayshree. Let's move on. We're looking at only about 5 minutes left of our official time. So
Okay.
we move on.
Because the rest of it is, yeah, it's not very difficult, but it's quite important. This part, the need to be proactive. So, what has changed this year, right? We've had this code that has come in, but what's always been there is the liability of employers in terms of Section 60 of the Employment Equity Act. And the case I set out there is a very interesting case, but the judge also said that your Section 60 introduces what we call a common law principle of vicarious liability. That means that the complaint of the harassment must be brought to the attention of management. Once that is done, the employer is then obligated to consult with all the relevant parties, take the necessary steps. And in this case, the necessary steps do not mean taking disciplinary action against the perpetrator. The steps must be aimed at eliminating the conduct. Taking disciplinary steps does not, of necessity, lead to the elimination of the conduct. That was in 2020. You now see in 2022, we have the Code of Good Practice, and that also says it's a Code of Good Practice on the prevention and elimination of harassment in the workplace. You need to go back and look at what is the root cause. Taking disciplinary action means that you are dealing with a dispute that arose. What was the conflict underlying that dispute? You need to see if you can prevent that from happening again. The second most important thing that you need to know is that from 2025, you had the Employment Equity Act, which was amended in January 2025, and the new regulations also came out in April 2025. The most important thing you need to know is that Section 53 of the Employment Equity Act sets out the requirements that have to be fulfilled to obtain a compliance certificate. So any company or any business that wants to do business or provide services with any organ of state has to obtain a compliance certificate from the Department of Employment and Labor. And one of the things they have to show to get the compliance certificate is that there has been no finding by the CCMA or the court that the employer breached the unfair discrimination provisions of the Employment Equity Act in the previous 12 months. What that means is if your company wants to do business with any organ of state, that organ of state can say, I need to see your compliance certificate. The minister or the Department of Employment and Labor will only issue that certificate if you didn't have an arbitration award or a labor court judgment which contains an adverse finding against you based on unfair discrimination. Bearing in mind, harassment is a form of unfair discrimination. So if you have a finding against you, you're not going to get the compliance certificate. That applies to designated and non-designated employers. So designated employers will have to get the compliance certificate. They also have to comply with the employment equity plan and reporting provisions. So even if you are an employer with less than 50 employees and you want to do business with an organ of state, every year you have to get your compliance certificate. Okay. So that is what, and the first compliance certificates are going to be issued to all employers in 2025. In the next 12 months, you have to apply for it and you have to show that there's been no adverse finding, which means that you need to try your very best to stop a matter or a dispute from being referred to the CCMA or the labor court, and you now need to contain it and you need to then take steps. So I've set out on the next slides, which you will receive, some steps that you can take, people-centered steps. Have a harassment policy, review your internal policies. Most importantly, number 3, do a risk assessment in the workplace. When you're doing a risk assessment, the question you're going to say is, who do I ask? Are the line managers going to tell me as the HR or the AR person that this is what is happening? My suggestion is do an anonymous survey or a poll that is inclusive of all employees, asking them, do you feel safe in this workplace? Are you comfortable reporting an issue of harassment? Ask very general questions, but conduct your survey throughout your workforce. That will give you an idea of what your risks are. Okay? have your visible reporting channels, and you can read the rest of your slides on your own. Just on concluding remarks, I am going to say that it's very important. The code says that there's the intersection of factors such as race, religion, gender, or disability increases the risk of harassment in the workplace. We all come to work 5 days a week, 8 hours a day, from different backgrounds, different genders, different upbringings, different religions. We have different beliefs. And obviously, all of this is going to increase the risk of harassment in the workplace. So you need to be proactive, do diversity and inclusivity training, do customized harassment training in your workspace. There's no one size fits all. After you do your survey, find out what are the issues, get a service provider to customize your training material, and make sure you train every level of employee, not just shop floor and junior employees, managers, senior managers, even your executives. You must remember that employees are more vocal about harassment issues in the workplace. You've got social media, technology, people are talking about issues, people are prioritizing their mental health over job security. So they are going to speak up about this. So what you need to do to be proactive is train, raise awareness in your workplace about the code, and try to take steps when you see a problem brewing to deal with it and be proactive. Okay, I rushed the last bit. I apologize. I'm mindful of the time at 16:01.
Thank you so much, Jayashree. Yeah, unfortunately, we are always bound by time. We never have enough of it. But a big thank you, firstly, to everyone who has joined us today and spent this time with us. And of course, to you as well, Jayashree, for your most valuable insights. Please, everyone, don't hesitate to reach out to us at Conflict Dynamics if you would like to explore the possibility of customized harassment awareness training for your workplace. It is something that we do a lot of work in, and that we would be more than happy to craft a proposal for you on. Or if there's anything else discussed in this session that you would like to explore a bit further, then please do feel free to reach out to us at Conflict Dynamics. And if it's something that requires Jayashree's direct attention, we will certainly put you in touch with her. So go well, enjoy the rest of your afternoon and evening, and we look forward to seeing everyone again when we run our next session, our next coffee session. Go well, everyone. Thank you.
Thank you, Vanessa. Thank you, everyone.